Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content. And today will be the day I earn your subscription. For today's coverage, we are covering a case dealing with the Boston Marathon bombing, which has been, of course, going through the various levels of appeal as cases do. And the United States Supreme Court has come up with an opinion today that was just released today relating to the sentencing of one of the people involved, Mr. Tarznev, who was originally sentenced to death by the trial court, and then that sentence was overturned by the Court of Appeals. And now the United States Supreme Court is overturning the Court of Appeals, so reinstating the death penalty. So we're going to discuss this case, and we're going to discuss the reasoning of this case and what happened and why the U.S. Supreme Court is making the decision it is. So we're just going to go through this decision and discuss it. And so let's get started with this. So this is the case of United States of America versus Dalskazar Tarznev. Justice Thomas has delivered the opinion of the court today. On April the 15th of 2013, the Tarznevs planted and detonated 2 homemade pressure cooker bombs near the finish line of the Boston Marathon. So right away you notice that this case has been going on for a while, right? It takes a little while to get to trial. Obviously, it takes a little while to get to trial, particularly in a death penalty case. Death penalty cases in particular can take some time. I forgot to put the text on screen, which is bad, but yeah, death penalty cases can take some time to get to trial. They can take some time for those to be resolved. The jury has to hear the death penalty things. The appeal takes time. The U.S. Supreme Court granting cert takes time. So, it's been a little bit, but, it takes time, particularly in death penalty cases, because the courts like to, be fairly thorough about it. The blast hurled nails and metal debris into the assembled crowd, killing 3 while maiming and wounding hundreds. 3 days later, the brothers murdered a campus police officer, carjacked a graduate student, and fired on police who had located them in the stolen vehicle. Dalskazar attempted to flee in the vehicle, but inadvertently killed Tarznev by running him over. So, inadvertently killed his co-conspirator's brother. Dalskazar was soon arrested and indicted. A jury found him guilty of 30 federal crimes and recommended the death penalty for 6 of them. Yeah, so in our system under the current law, right, the jury can only recommend the penalty, and the judge can technically overrule them at the trial level. But then that becomes a whole issue unto itself. The district court accordingly sentenced him to death. The Court of Appeals vacated, and we now reverse. So the death penalty is now back in play. All right, so let's learn a little bit about why. Let's learn a little bit about their history. The brothers immigrated to the United States in the early 2000s and live in Massachusetts. A little more than a decade later, they were actively contemplating how to wage radical jihad. They downloaded and read Al-Qaeda propaganda, and by December of 2012 began studying an Al-Qaeda guide to bomb making. On April the 15th of 2013, the brothers went to the Boston Marathon finish line on Boylston Street. They each brought a backpack containing a homemade pressure cooker bomb packed with explosives inside a layer of nails, BBs, and other metal scrapes. Tarznev then left his backpack in a crowd of spectators and walked away. Dalskazar stood with his backpack outside the Forum, a nearby restaurant where spectators watched the runners from the sidewalk and dining patio. 4 minutes later, Dalskazar surveyed the crowd. After speaking with Tamerlan by phone, Dalskazar left his backpack among the spectators. Tamerlan then detonated his bomb. While the crowd at the Forum looked towards the explosion, Dalskazar walked the other way. After a few seconds, he detonated his bomb. Each detonation sent fire and shrapnel in all directions. The blast from Tamerlan's bomb shattered Crystal Campbell's left femur and mutilated her legs. Though bystanders tried to save her, she bled to death on the sidewalk. Dalskazar's bomb ripped open the legs of Boston University student Lingzi Liu. Rescuers tried to stem the bleeding by using a belt as a makeshift tourniquet. She too bled to death. 8-year-old Martin Richard absorbed the full blast of Dalkazar bomb. BBs, nails, and other metal fragments shot through his abdomen, cutting his aorta, spinal cord, spleen, liver, pancreas, left kidney, and large intestine. The blast propelled shrapnel with such force it exited his back. Other shrapnel nearly severed his left hand. The explosion also caused 3-degree burns. Martin, the 8-year-old, ultimately died from blood loss. Dalkazar and Tomalin's bombs maimed and wounded hundreds of other victims. Many people lost limbs, including Martin's 6-year-old sister, Jane. Many more would have died if not for swift action of citizens and first responders. After leaving the scene, or fleeing the scene, the brothers returned to their normal lives. Dalkazar attended his college classes the next day. He went to the gym with friends. He posted online that he was a stress-free kind of guy, apparently. Several days later, on April 18th, after the Federal Bureau of Investigation released images of the suspected bombers, a friend saw the images and texted Dalkazar. Dalkazar responded, "Better not text me, my friend, lol." Recognizing the investigators were closing in on them, Dalkazar met up with Tomalin that evening. The brothers collected more homemade bombs and a handgun and loaded them into Tomalin's car. While driving past the Massachusetts Institute of Technology, they saw 27-year-old campus police officer Sean Collier sitting in his patrol car. They approached the car and shot him 5 times at close range, including once between the eyes. With Collier dead, the brothers tried to steal his service pistol, but were unable to remove it from the holster. They then carjacked and robbed another man, Dong Meng, who was driving his SUV home from work. When the brothers forced Meng to stop at the gas station for fuel and snacks, he fled on foot, and good for him. The brothers briefly chased him, but they gave up and made off with the SUV. Meng, the guy who owned the SUV, contacted the police, who used the SUV's GPS devices to track them. While the officers found the brothers in Watertown a few hours later, a street battle ensued. Tomalin fired on the officers with a handgun, while Dalkazar threw homemade bombs. When Tomalin's handgun ran out of ammunition, officers subdued him. As they tried to handcuff him, Dalkazar returned to the SUV and sped towards the officers. They evaded the SUV. Tomalin did not. Dalkazar ran over Tomalin and dragged him roughly 30 feet down the road. Tomalin disengaged from the undercarriage when Dalkazar rammed a police cruiser before escaping. Tomalin died soon after from his injuries. Dalkazar abandoned the SUV a few blocks away. He found a covered boat in a nearby backyard. Taking shelter inside, he carved the words, "Stop killing our innocent people and it will stop," into the planking. He also wrote a manifesto in pencil on the bulkhead of the boat's cockpit, justifying his actions and welcoming his expected martyrdom. The next day, the boat owners found him. Police eventually forced him out of the boat and arrested him. Well, that's a lot of background about these people, right? And some of this I did not know. I did not know, or at least have forgotten about the incident involving the campus security police officer. I did not remember that, or maybe never knew it in the first place, that they shot this guy, just sitting in his car, tried to steal his service rifles. And I knew about them being found in the boat, but I didn't know about, this incident with him being driven over by his, by the other guy in the car, and I didn't know about, the shootout and the bomb throwing and all the rest of it. So there were some details here that I'm learning just for the first time, I think. So, or at least being reminded of, because it's been a while. So either way, this all, by the way, of course, is established as a matter of fact because the jury has found guilt, which is not the issue on appeal. Never was. Right? The only issue that was on appeal, well, I'm sure it was an issue on appeal, but, it isn't at this point. I'm sure I'm almost 100% positive that they appealed on the basis of innocence issues, but that's not the issue now, right? The issue that we're trying to decide is not their guilt at this moment. The issue we're trying to decide at this moment is the issue of the sentencing. So these are all therefore established as a matter of fact. The Court of Appeals found the trial court's judgment fine, and that's not the reason the Supreme Court grants certiorari. So all these are facts now, because the jury found them. So that all happened. So that's a lot of stuff. Okay, so we need to learn a little bit about what happened at trial and at the Court of Appeals level with respect to the sentencing issues to determine how that went. So let's do that. A federal grand jury indicted Dolcazar for 30 crimes, 17 of which were capital offenses. In preparation for the jury selection, the parties proposed a 100-question form to screen prospective jurors. The district court adopted almost all of them, including many that probed for bias. For example, some of the district court questions asked whether a prospective juror had close association with law enforcement. Others asked whether a prospective juror had strong feelings about Islam, Chechens, or several Central Asian regions with which the Tarsnefs were connected. Still others asked whether prospective jurors had a personal connection to the bombing. Several questions also probed whether media coverage might have biased the prospective juror. One question asked if a prospective juror had formed an opinion about the case because of what they'd seen or read in news media. Another asked about the source, amount, and timing of a person's media consumption. Still another asked whether prospective jurors had commented on or posted about the bombing online. The district court did reject one of the media-related questions. So we're talking about the juror questionnaire, the voir dire questions, the written questions to the prospective juror. And the district court gets to obviously approve or disapprove those questions. And so one of the proposed questions was rejected. The proposed question had asked each prospective juror to list the facts he had learned about the case from the media and other sources. Concerning such a broad, unfocused question would cause more trouble by producing unmanageable data of minimal value that would come to dominate the entire voir dire. The district court declined to include that question in the questionnaire. After Dolcazar objected to removal, the district court further explained the question was too unguided. Okay, so the defense wants to ask this question of the jury. They want to ask the question, and they want to ask many questions. And one of the questions they want to ask is exactly what facts did you learn about this case from the news media? And when did you learn them? And the district court is saying no, that question is too untargeted. We're going to learn a whole bunch of information, and that's going to really dominate the entire thing. And it's not going to be particularly helpful to us. So the question is more, the juice is not worth the squeeze, as they say sometimes, right? It's not worth the hassle. It's too much hassle for too little gain. So I'm going to reject the question on that basis. That was the trial court's determination. Okay, let's press on. Recognizing the intense public interest in the case, the district court summoned an expanded jury pool. This is very typical, right? And this is like the first step you do before you do a change of venue. Change of venue is a disfavored remedy. It's disfavored, right? You want the trial to be heard in the place where it occurred. This is the norm, right? And so you can worry about whether or not you can get a fair jury of that, right, in that place, which is one of the reasons you change venue. But change of venue is a disfavored remedy. Much more common is this solution. Let's just expand the jury pool, right? Let's ask more jurors than we normally would. Let's ask for more people than we normally would, because we're going to reject more of them than in a typical case. So we'll just do a bigger pool to find a reasonable jury. This is a much more typical intermediate remedy. It's only like if this fails that you would consider a motion to change venue, which is, as I say, a very unfavored remedy. So in January 2015, the jury is starting. So the court calls 1,373 prospective jurors for the first round of jury selection. That's a pretty big pool. 1,400 jurors is a pretty big pool. After reviewing their answers to the questionnaire, the court reduced the pool to 256. As the jury selection began in earnest, Dolcazar renewed his request. The court asked each juror about the content of the media that he had consumed. The district court again refused the blanket request and instead permitted counsel to ask appropriate follow-up questions about a prospective juror media consumption based on answers to questions in the questionnaire or voir dire. So again, we're not going to allow you to do it blanketly. If there are particular things you want to inquire about based on particular answers, we'll allow those particular questions. But we're not going to do it in a blanket fashion. Okay, fair enough, so according to the district court. Several times the court permitted Dolcazar's attorneys to follow up with prospective jurors' earlier answers with specific questions about what a juror had seen in the news, so sometimes they allowed it. Over the course of 3 weeks of in-person questioning, the district court and the parties reduced the 256 prospective jurors down to 12. After the district court seated the jury, the case went to trial. Dolgozar did not contest his guilt and thus returned a guilty verdict. So guilt was not a factor in this case. He wasn't contesting guilt, which is a potential strategy for a lawyer, right? Especially in a death penalty case, right? It is a potential strategy to save, if your guy is guilty, dead to rights, as it were. It is a potential strategy to confess guilt in an effort to save whatever shred of credibility you have, for the sentencing phase, right? If you piss off, the idea being, obviously, if you piss off the jury by bringing a defense that doesn't make any sense, and wasting their time, the jury is going to hate you a little bit. And so it'll make it slightly harder. So if you think that they have you on the guilt phase, it is a potentially viable defense strategy to concede guilt and save your credibility and your ammunition for the guilt phase, so that you don't unduly lose the same jury from the guilt phase or from the trial phase. So that's a potential remedy or potential strategy. During the sentencing phase, the government argued that Dolgozar's crimes warranted the death penalty. Dolgozar's mitigation theory centered on the idea that Talmarin masterminded the bombing. According to Dolgozar, he was not sufficiently culpable to warrant the death penalty because his older brother had pressured him to participate. I mean, that's a strategy. To prove Talmarin's domineering nature, Dolgozar sought to introduce hearsay evidence of a crime Talmarin allegedly committed years earlier. Specifically, FBI agents investigating the bomber had come to suspect that Talmarin's friend, Ibrahim Tozhadef, possessed information about an unsolved triple homicide in Waltham, Massachusetts, where a non-Muslim acquaintance of Talmarin and two others were found bound, robbed, and murdered with a knife. So the older brother, this might have not been his first rodeo. When the agents went to interview Tozhadef a month after the bombing, Tozhadef initially denied any involvement. Yet when pressed, he told the agents that Talmarin had hatched a plan to rob the three victims of drug proceeds on the night of September the 11th, 2011. According to Tozhadef, he and Talmarin traveled to Waltham, held the men at gunpoint, and duct taped their hands, feet, and mouths. After taking the money, Talmarin insisted on killing the three men. According to Tozhadef, after he disagreed, Talmarin told him to wait outside while Talmarin cut their throats with a knife. So he has some prior history here, it seems. Yeesh. The agents offered Tozhadef a pen and paper to write out his confession. Tozhadef instead attacked the agents, who killed him in self-defense. That's one way to go, right? So this is this other guy who's involved. This other guy who's involved with this. Not the brother, but this other guy who's involved, and his older brother are involved in this. And they offer him a pen to write out a confession. And instead he attacks, I'm going to kill them with a pencil. But actually, no, not so much, it turns out. Actually, it turns out that the FBI shoots him, and he dies. So we have essentially rando guy's confession about what he did with the other brother. Now, rando guy's confession is certainly admissible against him, and it's probably admissible against the brother in a conspiracy theory, but not against him because he's not involved in this. So it's a hearsay thing. And obviously we can't cross-examine him because he's dead. So yeah, that's going to be a problem. In a lead-up to the trial, the prosecution told Dolgozar's counsel what Tozhadef had said, but didn't turn over the recording of the interview or the FBI reports. The prosecution also disclosed that Dias Kabriev, a friend of Dolgozar facing federal obstruction charges in connection with the bombing, told investigators that Dolgozar knew about Talmarin's involvement with the murders. Meanwhile, the government's analysis found evidence that someone had searched for evidence about the Waltham murders from Talmarin's wife's computer a week before they took place. Government investigators also found jihadi propaganda advocating theft from non-Muslim infidels. Before trial, Dolkazar filed a motion to compel production. We're not talking about Sandy Hook today, guys, so let's stay on topic, please. The government filed a motion in limine to exclude any reference to the Waltham murders, contending the evidence was irrelevant, or at least lacking so lacking in probative value, and so likely to confuse the issues the court should exclude. That too. The district court granted government's motion in limine. As the district court saw things, the evidence did not show what Talmarin's role was, and that Toshdev dead, no further line of inquiry remained. The available information was without probative value, which excuse me. One moment, please. Pardon me, I apologize. So yeah, it's without probative value in this context. Because it doesn't what would make it probative is whether or not it would influence this criminal trial, which it doesn't, right? So it doesn't really have any probative value in so much as it wouldn't impact the facts of this trial. And also, it would confuse the jury because it confuses the issues, which is the issues at this trial, and is a waste of time. So yeah, all those reasons make total logical sense. I'm fine. Okay. When the sentencing proceedings finished, the jury concluded that Dolkazar warranted the death penalty for 6 of the 17 death penalty eligible crimes, despite Dolkazar's argument that Talmarin was more capable. The district court accordingly sentenced him to death. Yeah, it seemed like some sort of acid reflux or something like that. The Court of Appeals vacated Dolkazar's capital sentence on 2 grounds. Okay, so now we've gotten past the trial stage, right? We've learned all the trials about the trial stage. So what have we learned? We learned that the district court denied a specific question in the voir dire about the specific facts that people had learned from news media, but did allow specific follow-up in at least some situations with specific jurors as warranted, but didn't allow for a blanket question. And then we learned about, this other thing with this other thing being excluded because the trial judge says, among other things, is hearsay, which it is. It confuses the issues, which it does, because the issue we're trying to resolve at this particular moment is his culpability for this particular crime, not his brother's and rando guy's culpability for some other crime. And it would confuse the issues and so forth and so on. So the district court's reasoning seems reasonable to me, but now let's go to the Court of Appeals level, who apparently disagreed at least in part, so we'll read as to why. Okay, the Court of Appeals vacated the capital sentence on 2 grounds. First, the Court of Appeals held the district court abused its discretion during jury selection by declining to ask every prospective jurors what he learned from the media about the case. So this is the correct standard. Abuse of discretion is the correct standard. And the Court of Appeals found that this was an abuse of discretion. Okay, according to the panel, such questions were required by that court's 1968 decision in Patricia versus United States, which had mandated this voir dire rule in the exercise of the court's appeals discretionary supervisory powers, not as a matter of constitutional law. Okay, so what's going on here is that every superior court has supervisory powers over the inferior courts, which obviously ends at the U.S. Supreme Court. So the U.S. Supreme Court can impose on the lower courts not only for constitutional reasons, but also can impose on them for like supervisory reasons. So things that are not constitutionally required, the Supreme Court can require as a matter of practice because it's a supervisory court. And obviously the Court of Appeals can obviously impose on their lower courts for the same reasons, right? So that's what they're saying, right? They're saying this question is required, not because the Constitution requires it, but rather because we, as a Court of Appeals, have imposed it in our supervisory role. So we are requiring it artificially, which is a thing, of course, the Court of Appeals can do. But then, of course, the Supreme Court, who has supervisory authority over them, can, of course, reverse that decision. So I think maybe that's where we're going. The Court of Appeals ruled the district court's failure to comply with the prior case was error of law and so abuse of discretion. Second, the panel held the district court abused its discretion when it excluded from sentencing the evidence concerning Tal Morin's possible involvement in the Waltham murders. The panel believed the evidence was sufficiently probative of the ability to influence, and we grant certiorari. Okay, fair enough. So the Court of Appeals is applying the right standard. Whether or not they're applying it correctly is something I suppose we're going to be deciding, but the correct standard is abuse of discretion. And they say two things. First, as to this media question, we're requiring it, and you are bound by our precedent, which you are, trial court, and so you had to do this, and you misread our case law, so, bad on you. And also, we are going to say that, this influence question was sufficiently probative. Now, remember, the only issue we're trying to solve is the death penalty because he pled guilty to the underlying offense, right? So we're not trying to determine whether or not there was a prejudice that went to the conviction because he pled guilty. But we are trying to determine if there's a prejudice that went to the verdict, or the sentence. And there's only two possible sentences in this circumstance: life imprisonment or the death penalty, right? Because of the number, you can follow the chart, and on the guidelines, it's pretty clear. It's either the life imprisonment or the death penalty. So, if the trial court screwed up, then we can just impose the other penalty because there's only one possible conclusion as a matter of law, which would be life imprisonment. So, makes logical sense. Let's read on. The government argues the Court of Appeals improperly vacated the capital sentence based on the juror questionnaire and the Waltham evidence. We agree. So, reversing on the abuse of discretion standard. The Sixth Amendment guarantees the accused the right to a trial by an impartial jury. The right to an impartial jury does not require ignorance. Notorious crimes are almost always, as a matter of necessity, brought to the attention of those informed citizens who are best fitted for a jury. A trial court protects the defendant's Sixth Amendment rights by ensuring the jurors have no bias or prejudice that would prevent them from returning a verdict according to law and evidence. We have repeatedly said that a jury selection falls, particularly within the province of the trial court judge. Yes, that is correct, which is why the relevant standard would be abuse of discretion, right? This is a matter of trial court discretion. That is so because the trial court judge appraisal is ordinarily influenced by a host of factors impossible to capture fully on the record, which is true, such as prospective jurors' inflection, sincerity, demeanor, candor, body language, and apprehension of duty, right? Because at the Court of Appeals level or the Supreme Court level, all you have is a transcript, which doesn't cover everything, right? So the Court of Appeals, or the Supreme Court for that matter, when they're thinking about the trial court's role, have to bear in mind the trial court has more information than is available on the record. And so you have to think about those things as you're considering whether or not the trial court made a mistake. A trial court's broad discretion in this area includes deciding which questions to ask the juror. A court of appeal reviews the district court's questioning of prospective jurors only for abuse of discretion. That's the correct standard, right? So the court of appeals apparently has the right standard. It's the right standard. It's just an issue of, apparently the Supreme Court just disagrees that they apply the standard correctly, which, is, interesting. That's interesting as an issue, because it is disfavored, and I believe there's a Supreme Court rule specifically on point. But I believe it is disfavored for certiorari, for the Supreme Court to grant certiorari when a lower court applies the right rule but applies it incorrectly, right? So if the lower court applies the wrong rule, then the Supreme Court will grant certiorari. But I believe in the rules, I believe in the Supreme Court's rules, it's explicitly stated as disfavored to grant certiorari merely when the lower court applied the correct standard but made a mistake in its application. So it's a little bit strange that the Supreme Court will grant certiorari, because that is disfavored to my memory by the Supreme Court rules. But that's where we are. The discretion does not vanish when a case garners public attention. Indeed, when pretrial publicity is at issue, primary reliance on the judgment of a trial court makes especially good sense. After all, the judge sits in the locale where the public publicity is said to have its effect, and may base her evaluation on her own perception of the depth and extent of news stories that might influence the juror. Because conducting voir dire is committed to the district court's sound discretion, there is no blanket constitutional requirement that it must ask each prospective juror about what he heard, read, or saw about a case in the media. Instead, as in any case, the district court's duty is to conduct a thorough jury selection process that allows the judge to evaluate whether each prospective juror has believed what he says when he has said he's not formed an opinion about the case. 999 from Stephen Light. Yay, now accelerate this, proceed with legal remedy. Finn. Thank you for your super chat, Stephen. The district court did not abuse discretion by declining to ask about the content and extent of each juror's media consumption regarding the bombings. The court recognized the significant pretrial publicity concerning the bombings and reasonably concluded that the proposed media question was unfocused, risked producing unmanageable data that would at best shine light on preconceptions that other questions have already probed. At voir dire, the court further explained that it did not want to be too tied to a script because every juror is different and has to be questioned in a way that was appropriate to the jurors' each earlier answers, which is perfectly reasonable. Bliv says you should probably get off the internet, seem a little addled. That's mean. Addled? The court was concerned that the media content questionnaire had the wrong emphasis, focusing on what a juror knew coming before court, rather than potential bias. Based on years of trial experience, the court concluded that jurors who came in with some prior knowledge would still have to act impartially and hold the government available to its proof. The district court discretion was reasonable and well within discretion, as our precedent had made clear. If any doubt remained, the rest of the jury selection process dispels it. The district court summoned an expanded jury pool of 1,373 jurors, which seems like a lot, and used the 100-question juror to cull that down to 256, which still sounds like a lot. The questionnaire asked prospective jurors what media sources they followed, how much they consumed, whether they ever commented about the bombing in letters, calls, or online posts, and most poignantly, whether any of that information caused the prospective jurors to form an opinion about guilt or punishment. The court then subjected those 256 prospective jurors to 3 weeks of individualized voir dire, in which the court and both parties had the opportunity to ask questions appropriate for advice. 3 weeks of voir dire is a long-ass time, particularly in federal court. Federal court is somewhat notorious for not allowing an expanded voir dire. So 3 weeks for voir dire in federal court is a long ass time. Let's see, where are we? The Dulcazar's attorney asked several prospective jurors what they had heard, read, or even seen about the case in the media. The district court also provided emphatic and clear instructions on the sworn duty of each juror to decide the issues only on the evidence presented in open court. The court reminded prospective jurors they must be able to decide the issues in the case based on information or evidence that presented in the course of trial, not on information from other sources. In sum, the court's jury selection process was both eminently reasonable and wholly consistent with the court's precedents. With this court's precedent. The Court of Appeals erred in holding otherwise. So yeah, this is just, the Supreme Court smacking down the Court of Appeals for, imposing this requirement as a matter of its supervisory authority. It's like, yeah, a Court of Appeals, you can do that. But then again, trial courts get discretion as a matter of law, and you unduly impeded them in that role. And we're the Supreme Court, so, we get to overturn you, because that's one of the things we do with our time. So we're going to basically overturn this other case, because, we can. The Court of Appeals erred in holding otherwise, as it saw its decision nearly 50 years prior in a prior case had, pursuant to its supervisory authority, required district courts presiding over high-profile cases to ask about the kind and degree of exposure to the case or the parties. And because this purportedly set forth a rule, the district court's failure to follow it was an error of law and so an abuse of discretion. It is true that some of our precedents describe supervisory authority that it inherits in federal courts. Yes. But the court's precedents have also identified clear limits. When lower courts, that would be in this case the Court of Appeals, the lower court, has the ability to invoke that authority. For example, supervisory rules cannot conflict with or circumvent a constitutional provision or federal statute, nor they can conflict or circumvent a federal rule. Finally, and most relevant here, lower courts cannot create a prophylactic, which is a protectionary supervisory rule that circumvent or supplement legal standards set out in decisions of this court. So, only we, the Supreme Court, can institute these prophylactic rules. So, not you so much. Well, we can, but not you. And we're a supervisory court that beats you, so, get in your lane. The split on this opinion was 6-3. I don't know how it's a drill. I don't know. I mean, we went through the facts of the thing. I don't know. I mean, the terrorist might have said all kinds of things, but I don't know how him setting off a bomb in a public space, and I don't know how him shooting a campus cop who was sitting in his police car in the face, and I don't know how engaging in a shootout with the police is a drill in any sense. I mean, that doesn't make any sense to me. And also, I'd like to remind you, he pled guilty. So there's no question as to the issue of so you guys saying drill, it's a drill, is just counterfactual at this point, because he pled guilty. If he was trying to say, if you guys are under the impression that this was in some sense inspired by the government or something, he pled guilty. He didn't plead like an entrapment. He didn't plead anything. He pled guilty. He said that, yes, I committed those crimes. So there's no question as to guilt, that he actually in fact did those things with the intent to kill people and so forth and so on. So I don't know what you guys are arguing about in drill or not. And maybe he said that at one point. I can't speak to that issue, but what I can say is he pled guilty. And the only issue at this point is the sentencing. So he did, in fact, with intent, murder many people, including police officers and so forth and so on. So I don't know what you guys are talking about in chat, nor is it relevant to the issues at hand, with all possible respect. Okay, so Painter, a different case, exemplifies this last limit. There, a federal district court asserted its supervisory power, which it also has, unto itself, obviously, to suppress illegally seized evidence, even where the seizure violated a third party's Fourth Amendment rights, and the Court of Appeals affirmed the decision. So this would go to what we sometimes call a Fourth Amendment standing issue, which is not the same as Article 3 standing issue. And said, so the district court in its wisdom said, you know what, this violates a third party's rights, but I'm still going to suppress the evidence anyway. And the Court of Appeals said, okay. But then the Supreme Court says no. This court reversed, explaining the Fourth Amendment jurisprudence has established beyond any doubt a defendant cannot assert a third party's Fourth Amendment injury in order to suppress. Were we to accept the use of this power, of supervisory power, we would confer on the judiciary discretionary power to disregard considered limitations of laws it's charged with enforcing. Simply put, the supervisory power does not extend that far. Nor does any supervisory power extend as the Court of Appeals appears to suggest in this case. The court has held many times the district court enjoys broad discretion to manage jury selection, including what questions to ask. As the Court of Appeals acknowledged, our cases establish that a reviewing court may set aside a district court's questioning only for abuse of discretion, which means that the Court of Appeals, under its supervisory power, cannot, impose more requirements than that. It's up to the trial court within an abuse of discretion standard. The Court of Appeals declined to apply that standard. Rather, they asked whether media content questions were necessary. In light of district court's exhaustive voir dire, the Court of Appeals resurrected some prior case, which handed down a purported legal rule that media content questions are required in all high-profile cases, and then concluded it was legal error. But a Court of Appeals cannot supplant the district court's broad discretion to manage voir dire by prescribing specific lines of questioning, and thereby circumvent a well-established standard of review. Whatever the supervisory power entails, it does not countenance this use of it. I tend to agree. Under the relevant legal rules, right? I tend to agree. The trial court has very broad discretion, right? And to get that discretion overturned is very, very difficult. The trial court gets a lot of discretion. This discretion not only extends to what kind of questions to allow in voir dire, but it can, although not necessarily, but can extend to what witnesses to allow, even if otherwise meeting all the rules, right? So you can exclude witnesses for, particular reasons. The most common will be cumulative, but there might be other reasons. It can extend to what questions to allow those witnesses to be asked or answered. And it also extends, in large part, to questions about evidentiary rules. Right, so the trial court gets lots of discretion. And so it's one of the reasons that, the trial court judges go through the process they do in terms of getting appointed, because of how much discretion they get. So the Court of Appeals role is somewhat limited, and it's for this reason that decisions from the trial court, on the whole, are very rarely overturned, where it sticks, because trial courts get a lot of discretion. And so here, the trial court used its discretion and be like, no, I'm not going to do that role. The Court of Appeals is like, you have to. Supreme Court's like, nah, you don't have to. You asked other questions that got to the same issue, and you ultimately got to the question of whether or not they can be unbiased. So you didn't have to ask that particular question. The Court of Appeals is wrong. You asked other questions that got there. You didn't abuse your discretion by preventing that particular question. Not going to happen. So... yeah, American Virtual. A lot of people don't understand how much discretion trial court has. Not easy to get reversal. Exactly true. Exactly true. Yeah. Defending a straw man says one person keeps insisting this was a false flag. That's why they keep talking about a drill. Again, that's not an issue in this case. It's simply not an issue in this case because he pled guilty. As a matter of law, it's not an issue in this case. He pled guilty. If there was a valid defense that, he was acting at some sort of behest of some sort of government or something like that, that could be a valid defense, right? Duress or something like that. Duress, entrapment, that could be a thing, but it's not a thing. He pled guilty to the underlying crime. He said, yes, I did the thing. I did the murders, which, imply or require, because I'm sure he allocuted as well. And we could pull the allocution if we really wanted to, but I'm sure he allocated to go through all the crimes and say, yes, I did those things. I did the things. I did the murders. It was me. So those are no longer an issue legally, right? He is in fact guilty. He in fact pled guilty. So the only questions we're trying to decide at this exact moment are the sentencing issues. We've dealt with one of them. Right? We dealt with one of them. The Court of Appeals reversed because the trial court didn't ask a particular question. We went through the relevant standard. The Supreme Court is correct. I mean, implicitly, of course, but also just on basic legal principles, they're correct. Right? This is not surprising in any way. The trial court gets a lot of discretion in terms of this. They asked questions to get to where they needed to be, and so them wanting to exclude this particular question is not an abuse of discretion, which is the particular standard. And the Court of Appeals cannot, as a matter of its supervisory function, insist on a particular question. That's not one of the things they can do. So that's the legal analysis so far. Should we continue to proceed with the legal analysis and go on to step 2? Let's continue with the legal analysis and go on to step 2. The Court of Appeals' second reason for vacating the capital sentences the district court erred in excluding from the sentencing provision the evidence of the Waltham matter fares no betters. The Federal Death Penalty Act sets out a comprehensive scheme by which federal courts adjudicate, review, and impose death sentences. The relevant law provides that at sentencing phase of capital trial, information may be presented as to any matter relevant to the sentence, including any mitigating or aggravating factor. Information is admissible regardless of its admissibility under the rules governing admission of evidence at criminal trials. So this is true, right? The standards at sentencing are much different than they are at the trial level. So all kinds of fun and exciting evidence can come in at the sentencing phase as compared to the liability phase, which again we didn't have to do because we found he pled guilty. So liability phase is over, so all kinds of new and fun and exciting evidence comes in. Okay. Check 1 2. Check 1 2. I think maybe I'm slightly hot on the mic. Check 1 2. All right, that's better. Okay. That said, the Federal Death Penalty Act proceedings are not evidentiary free-for-alls. The district court may exclude evidence under the FDPA if its probative value is outweighed by danger of creating unfair prejudice, confusing issues, or misleading the jury. We reviewed these exclusions, again, for abuse of discretion. Right. Because that's a question now, right? Is it this or is it that? Is it more probative or is it more prejudicial? That's like a factual determination, not a legal determination. So, we're going to review that for abuse of discretion. That makes total logical sense. Here during sentencing, Dolcazar sought to introduce evidence linking Talmarin to the unsolved Waltham murders. He argued the evidence supported his mitigation evidence that Talmarin was the ringleader. The district court acknowledged the rationale but excluded the evidence because it was without any probative value and would be confusing to the jury. That conclusion was reasonable and not an abuse of discretion. Dolcazar sought to divert the sentencing jury's attention to the triple homicide that Talmarin allegedly committed years prior, though there was no allegation that Dolcazar had had any role in that crime. Nor was there any way to confirm or verify relevant facts since all the parties involved were dead. As the district court explained, there simply was insufficient evidence to describe any participation Talmarin may have had or tell who played what role if they played any particular roles. The district court did not abuse its discretion when finding the evidence lacked probative value, which would confuse the jury and ultimately be nothing more than a waste of time. Again, a district court could potentially go the other way on this, and it wouldn't necessarily be wrong for a district court to go the other way on this. This is an abuse of discretion, right? The question is it substantially more prejudicial than probative? So a district court could potentially go the other way, and that would be legally reasonable too, because it's a question of fact, which means it's committed to the fact finder, which in this particular instance is the trial court, who's the fact finder for this particular exercise. They be the fact finder for this particular exercise, by the way, if there's a jury or not, because the question is a threshold question, right? Do you even give it to the jury? Is it so much more prejudicial than probative? The jury should even be allowed to hear that, which means it's a fact question, but it's a fact question the trial court has to ask as a threshold question. And so a court could go the other way, potentially. The question is it abuse of discretion to go this way? And it's like, no, I don't think so. I don't think that, it's probably reasonable either way. And we, as a court of appeals in particular, we would be ill-suited to second-guess that decision, because part of that analysis, again, is necessarily going to be based on only things the trial court can see and hear, because all the Court of Appeals has is the transcript. The trial court has the benefit of seeing the parties. All the parties, whether they're witnesses, the attorneys, the defendant, whatever, right? And hearing them and seeing their body language and all the rest of it. So they have more information. So we have to remember that as we're doing our analysis. So it's like, well, yeah, there might be a basis to exclude that. Seems plausible. Dalcazar in the dissent offers several countering arguments, none of which is convincing. First, Dalcazar suggested the violation of the Eighth Amendment balancing test operates to exclude any relevant mitigating evidence. So we want to say it's an Eighth Amendment violation. That seems unlikely. His argument depends on a line of cases rooted in Lockett versus Ohio and Eddings versus Oklahoma, which require the sentencing court, or the sentencer, to consider mitigating circumstances when deciding whether to impose the death penalty. Dalcazar suggests that a district court violates the Eighth Amendment under these precedents if it excludes any marginally relevant mitigating evidence that fails the balancing test. Okay. Our cases do not support Dalcazar's extreme position. Lockett and his progeny stand only for the proposition that a state may not cut off in an absolute manner the presentation of mitigating evidence, either by statute or judicial instruction, or limiting the inquiries to which is relevant. So severely, the evidence could never be part of the sentencing decision at all. So basically, this makes everything possible in sentencing. It makes everything possible, but still there's a role for the trial court to play. So like so many of the rules of evidence kind of go by the wayside. And like a lot of stuff can come in, both for the government and for the defendant, incidentally. So like everything, so the universe of possibilities is much more open. And in some senses infinite. But there's still a role for the district court to play beyond the rules of evidence. Because as I kind of pointed out earlier, like even if we were talking about the rules of evidence, we would still be able to potentially exclude witnesses or potentially exclude particular kinds of questions of witnesses, right? So even if no rule of evidence was violated, even if no rule of procedure was violated, a trial court could potentially exclude a particular question or potentially exclude a particular witness because of factors such as it would mislead the juror or would be unduly cumulative, or things that would go the other way. So that's possible. And if it's possible in that context, it's possible in this context. So that makes sense. We read the principle to coexist with the overlapping goal that above all, capital sentencing must be reliable, accurate, and non-arbitrary. Thus, our capital sentencing jurisprudence seeks to reconcile these two competing principles, to allow mitigating evidence to be considered, and to guide the discretion of the sentencer. Right, these are two values we're trying to hold at the same time. Okay. To effectively reconcile these objectives, we need only conclude it's consistent with the Eighth Amendment for the federal government to channel the sentencing consideration of defenders, arguably mitigating evidence, so as to limit the relevance of that evidence in any reasonable manner, so long as the federal government does not deny the defendant a full and fair opportunity to apprise the sentencer of all constitutionally relevant circumstances. Because the states and federal government retain traditional authority to decide certain types of evidence may have insufficient probative value to justify admission, they may enact reasonable rules governing whether specific pieces of evidence are admissible. This sounds perfectly logical. Moreover, we've expressly held that the Eighth Amendment does not deprive the sovereign of its authority to set up reasonable limits upon the evidence a capital defendant can submit and control the manner in which it's submitted. So, like, yeah, your right to a jury, doesn't mean that you have the right to put everything before a jury. There are limits, and there always have been limits, and these limits go far and deep in law as you like, which, again, when you're interpreting constitutional provisions, looking at the relevant history is always important, because we've talked about this in the Second and First Amendment context, right? It's not a right, it's the right. And what is the nature of the right? What is the nature of the right to a jury? What is the nature of the freedom of speech? What is the nature of the freedom to bear arms? Right to bear arms? And so forth and so on. What is the nature of the right? How was it understood? And the right has never meant, and does not mean now, the right to just put anything before a jury for the hell of it, right? There are some limitations. And there is a proper role for the court as a threshold in determining what that is to at least some degree. It's not infinite latitude. There's abuse of discretion, and there's rules and constitutional cases to be sure, but there's some role. There's some role. Makes sense. Congress's passage of the relevant law falls well within the traditional authority. The relevant law sets up a highly permissible regime that allows criminal defendants to introduce a wide range of normally inadmissible evidence. The statute channels that evidence through an individualized balancing test that affords a capital defendant every reasonable opportunity to place the relevant mitigating evidence before the penalty phase jury. Unlike the statute charged in Lockett or a sentencing decision charged in Eddings, the statute does not put any category of mitigating evidence beyond purview. So it's not categorical. It's not categorical. It has to be considered more individualized. Rather, the relevant statute preserves the traditional gatekeeping function of the district court judges to consider and assess specific pieces of relevant evidence in light of, for example, probative value and risk to the potential truth-seeking function of the jury. The court weighs all the proffered evidence to determine whether it will assist the jury in considering any grounds for mitigation. Put simply, the statute does not deny a defendant a full and fair opportunity to apprise the sentencer of all constitutionally relevant circumstances, and therefore does not offend the Eighth Amendment. Seems plausible. Dalcazar alternately disagrees with the balance the district court struck under the relevant statute, arguing that the evidence was highly probative to the mitigating defense. On his telling, the evidence shows that Talmarin was a leader who pressured others to commit violence, but the district court considered this argument and rejected it, after reasonably explaining there's just no way of telling who played what role if they played roles from the sparse and unreliable information before the court. It was thus plausible that Tolstoyev was the bad guy and Talmarin was the minor actor. In other words, the evidence did not tend to show Talmarin acted as a leader who pressured Tolstoyev into committing the crime, and certainly does not show that almost 2 years later, Talmarin and the domiciled Dalcazar acted in a manner that would mitigate the guilt. Dalcazar further opines he may have reduced juror confusion by putting the information before the juror in a streamlined manner. But it's important that a reviewing court evaluate the trial court's decision from its perspective when it had to rule, rather than indulge in hindsight review. Yes, again, you have to look at this at the time, and you have to look at within the trial court's role, right? Does it seem like the trial court is reasoning through this? Does it seem like they're considering everything? Does it seem like they're weighing things? And they're doing so under the appropriate legal standards? Does it seem like an abuse of discretion? Which, again, is pretty hard. Not infinitely hard, but pretty hard. So, Here, Dolcazar did not alert the district court to any possible streamlined approach. So apparently this is an issue we're raising for the first time on appeal, which is always disfavored, right? It's like, oh, well, we had a solution. We were going to do this in a really streamlined way. We had a plan. We were going to do this in a streamlined way. And under our plan, if it had been followed, it would have avoided many of these problems. So the district court abused its discretion in light of our plan. You know what the fatal flaw to that argument was? You didn't present the district court the plan. So they can't consider it. It isn't to say, incidentally, that if you had presented the plan and the district court had ruled against you anyway, that you would necessarily win, because abuse of discretion, right? But you didn't even give the trial court the opportunity to consider it and rule against you. So, not so much. So it didn't alert them to this possible approach, instead suggesting that if the court admitted the evidence, he would submit additional evidence and possibly seek third-party discovery, which sounds very unlike streamlined. Moreover, Dolcazar could not have unilaterally dictated how the proceeding would progress, because the government would be permitted to rebut any information received at the hearing with evidence of its own. That too. So no matter how Dolcazar presented the evidence, its bare inclusion risked producing confusion. In a mini-trial where the only witnesses who knew the truth were dead, the district court did not abuse its discretion by declining to lead the jury into this evidentiary detour. Which isn't necessarily to say that it would have abused its discretion by allowing it. Because again, abuse of discretion goes a long way. So, might be okay for the district court to go the other way, but this district court said to themselves, nah, I'm not about that life. And that was within the province of the province within this court, which sounds about right to me. Based on the relevant standards, abuse of discretion is pretty hard. Finally, Dolcazar argues since the government apparently considered the statement to the FBI agents reliable enough to justify its reference in a search warrant affidavit, which, give me a break, Tolshar's statements were necessarily reliable enough to be presented to jurors mitigating evidence. We fail to see why. This district court here did not sign the warrant or the affidavit. Whatever probable cause assessment the FBI agent and the magistrate judge made, the district court was free to evaluate that information independently, whether deciding it to admit under this. Right, so they're like different questions, right? They're different questions. Is it enough to grant a search warrant? Sure. Why not, right? It's hearsay, but hearsay is an evidentiary rule for like a trial, not necessarily for a search warrant. So like, is it fine for a search warrant? Sure. Yeah, why not? Is it okay to admit at the trial? Well, at a trial now, suddenly we have evidentiary rules and other considerations like confusing the jury and stuff. So different legal standards at different times. So totally, and also this court wasn't the one that issued it. And even if it had, it wouldn't necessarily be bound by that decision for the reasons I just said. So like, yeah. For its part, the dissent subjects the district court's decision to exclude the evidence to a more stringent standard of review, based on the independent review of the record that they would reverse. While the dissent acknowledges district courts enjoy significant discretion when making evidentiary decisions, and nevertheless argues that the death penalty context here requires us to scrutinize the decision with particular judicial care. So the dissent is of the view that because this is a death penalty decision, that we should be a little bit more willing to correct the court below. In doing so, the dissent ignores our traditional standards for appellate review of evidentiary determinations. It sure does. The dissent feels like this is special for some reason, but that would ignore the standard rule. Deference is a hallmark of abuse of discretion review, applicable to these decisions. Under standard law, that's true. A reviewing court applying that standard may not substitute its judgment for that of the district court. Rather, the appellate court must defer to the lower court's sound judgment so long as the discretion falls within the wide discretion and is not manifestly erroneous. Yeah, I mean, it's pretty wide. Even in the death penalty context, this is the traditional standard, which it is. Yet under this, the dissent proposes to independently reevaluate the decision to exclude the evidence. In particular, dissent joins Dolcazar in criticizing the district court's conclusion. The risk of confusing the jury outweighed the probative value. The dissent thinks that was the district court's strongest reason for excluding the evidence, but discounts the district court's conclusion for two reasons, neither of which is compelling under the deferential abuse of discretion. First, the dissent suggests that because death penalty proceedings are special, district courts should be more hesitant to find a risk of confusion in this context than others. But the dissent identifies nothing in the text of the Federal Death Penalty Act to support its position. Congress defined what considerations district courts must balance when making these decisions, and it chose to define one using a term familiar in a law of evidence, confusing the issues, which is a familiar standard. It's a standard under Rule 403 generally. Nothing in this Congress nothing suggests Congress intended to evaluate that standard differently under the FDPA. I mean, it is a standard term of law. Secondly, dissent points out to the district courts sometimes allows the government to present evidence of capital defense past bad acts during sentencing, despite the risk of eventually many trials. This is true. But many of these cases focused on the defendant's own conduct, not someone else's. In such cases, the government need only put forward evidence tending to show the defendant committed the past bad act. Here, the evidentiary showing would be substantially more complex and confusing. No one alleges that Dolcazar participated in those murders. As the district court reasonably concluded, the evidence available sheds little light on what role, if any, Tomarine actually played. To make his point in sentencing, then, Dolcazar would have to show, without any surviving witnesses, what role he played, which would be a little bit difficult. Then he'd have to establish that he learned of the crimes before planning the bombings. Finally, you'd have to explain about how his knowledge of a role 2 years old affected his own role in the bombings. Whatever other courts might think about this inquiry into defendant's own prior bad acts, the district court's reasoning risks confusing jury in its proceedings. We see no basis to disturb that conclusion. So Dzalkatar Tazmaref committed heinous crimes. The Sixth Amendment nonetheless guarantees him right to a fair trial before an impartial jury. He received one. The judgment for the Court of Appeals for the First Circuit is thereby reversed, which brings us to the end of the opinion, which makes total logical legal sense to my considered opinion. So yeah, this is perfectly reasonable and rational in my mind. So this seems like a fairly standard application of standard law. Like, this seems, yeah, fair enough. The Court of Appeals tried to impose an additional requirement on the district court using its supervisory role, which can be a thing that the Court of Appeals can do. The Supreme Court, of course, is a supervisory court to the Court of Appeals, so says, no, not so much with your supervisory role. It's dumb. Right, it's dumb. Right. And so, yeah. And then on this other one, like, it wasn't an abuse of discretion. Now, I will say what I said before, which is it's slightly odd. It is slightly odd, and it's worthy of note. And let me see if I can find the relevant Supreme Court rule real fast. Hold on. Let me see if I can find the actual rule, rather than just paraphrase it. Is it in Rule 10? Let's find out. Yeah, it is in Rule 10. All right, so there is a rule of the Supreme Court that's worthy of being mentioned as part of this analysis. So let's put it up on screen real fast and talk about it. All right. So here are the rules of the Supreme Court of the United States. All right. And we will skip to page. So the one we want is considerations governing the review of certiorari, which in this case is Rule 10, which can be located on page 5 of the rules. So we'll skip to page 5 of the rules and Rule 10. And I'll show you why it's at least partially concerning. Or partially unexpected, I should say. Not concerning, but partially unexpected. Okay, so here are considerations governing the rules of certiorari, right? And then it says, review of writ of certiorari is not a matter of right, but of judicial discretion. A petition for writ of certiorari will be granted only for compelling reasons. And then we skip to the end of the rule, which says specifically this. A petition for writ of certiorari is rarely granted where the asserted error consists of erroneous factual findings or the misapplication of a properly stated rule of law. Okay, so this is partially why it's a problem. $5 from, or partially odd. I should stop saying a problem. It's just odd. $5 from Anne Fernstein. As someone whose life was altered by an act of terrorism while visiting Israel, my emotional side was glad to see this. I know it won't erase pain. Yeah. So it's partially odd for the Supreme Court to grant certiorari because one of these seems like just a misapplication of the rule of law, right? One doesn't, right? The exclusion, excuse me one second. The failure to ask the question on voir dire. The failure to ask the question on voir dire. It makes sense for the Supreme Court to review that because the Court of Appeals, as part of its supervisory authority, just invented a law. So it is it's misapplication of a stated rule of law, but it's a misapplication of a stated rule of law because of another law, which also is misstated, right? Or it doesn't really exist. So it makes more sense for the Supreme Court to grant that half of it because it's like, yeah, you misstated the rule of law because actually it's even worse than that. You had the wrong law, right? You had the wrong law because you had this precedent which was wrong. So you applied the wrong law as to that half. So as that half, it makes sense. To the other half, it's a little bit odd. But then again, they come as part of a conjoined case. So I suppose that's the reason that we're in this position, right? So it might have been different. It might have been different if the only error was the issue with the presentation of this prior evidence, right? Because in that case, the Court of Appeals wasn't imposing its own special law from nowhere. In that, it was just imposing the standard law. So it might be the case, although we will never know for sure, but it might be the case the defendant in some way screwed himself because he raised two issues of error, right? He might have been better off only raising the one issue of error. If he had only raised the issue of, this prior incident involving his brother not coming in, if he had only raised that issue, and the trial court did what it did, and the Court of Appeals did what it did, right? The Court of Appeals properly stated the law. It misapplied it, but it properly stated the law. And as we just read in the Supreme Court rules, like merely misapplying the law is not enough. So it might be the case the defendant screwed himself by raising two errors, because one of those errors would be disfavored for the Supreme Court giving a hook. But the other one is a wrong error, it's a wrong law, right? The other one is, hey, wait a second, Court of Appeals, you applied the wrong law because you have this legal rule that doesn't exist or shouldn't exist, and we're going to say doesn't exist, right? So we'll grant certiorari for that reason. As long as we're hearing the case anyway, right, then this one can come along for the ride. So it might be the case, although we'll never know for sure, the defendant screwed himself by raising two errors, and one of them gave the Supreme Court a hook so that they could rule on both. Now, strictly speaking, of course, the rule only says it's disfavored. It doesn't say it's disallowed. But, it might have been different, maybe, if the defendant had only raised the one issue. So this might be a potential fail in the end by his legal team, although not necessarily a fail you could have seen coming. So it's not like a malpractice thing, but it might be, right? Because it's like, well, we have two reasons this is wrong, right? One of them is based on this circuit precedent, and you were supposed to do that. And one's based on abuse of discretion. But it might be by raising those two issues they gave the Supreme Court the hook and might have been better off with only the one. So we'll never know for sure, but an interesting little twist. 3,000 ISK from Gisley, who's Brian Gisjol This is for all the crap I've given you over the past couple of years, whether you've noticed it or not. Nothing but love. You also love Kraut so-and-so. Well, thank you. I try. So, yeah. So that's, what's going on in this case. So it makes total logical sense. So I hope you learned a little bit of something about the roles of trial courts, which are massive and expansive, and a little bit about something about the roles of the Supreme Court, and supervisory discretion, something I hope you learned some things of value in this legal analysis. So yeah, the death penalty sentence will get reimposed, and that's kind of probably the end of that, because the Effective Death Penalty Act would presumably preclude any sort of other motions. So it probably is the end of the road of appeals, unless it's for the particular method of appeal or execution, which may be depending on what's going on in that state. But so all that stuff. I've never had my name butchered like that, and I love it. Yeah. So I'm going to sign off for now. If you've enjoyed this stream, please remember. E.E. Caroline asked question tactically and rulefully, could they have done 2 appeals? No, you can only do 1 appeal, right? You have to, these are tactical considerations by a lawyer, right? You can't do like 2 separate appeals. Like, I'm going to appeal this issue and appeal this issue in 2 separate ways. No. It's like you appeal them, you have to decide what issues to appeal. And this is a tactical consideration about what issues you might appeal. Which, if you're the appellate lawyer, like in this situation, I don't know what you do. I don't know what the right answer in this situation is, because like, what are the odds of the Supreme Court getting involved? I guess in this case, not bad. So, but do you really make the decision to forfeit a promising ground of appeal? Right? Because I have, apparently, if I'm the appellate lawyer at the Court of Appeal stage, right, assuming that I know everything, and I'm very, very smart appellate lawyer, I still have to guess as to what's going to happen in the future. So do I, as super smart appellate lawyer, do I make the decision to forfeit an issue on appeal when it appears I have a binding Court of Appeals case that tells me the district court is wrong? Do I forfeit that because I know that because I know the Supreme Court could review on that basis, but then again, certiorari's are rare, and so forth and so on. So do I make the decision as the Court of Appeals to forfeit that legal argument? I mean, that's a tough one. What appellate lawyer is really going to have the balls to say, there's a binding decision from the Court of Appeals that tells me the district court's wrong, but I'm not going to appeal on that basis because of what the Supreme Court might do down the road? I mean, you'd have a tough time, although not necessarily an impossible time, but you'd have a tough time defending that on competent counsel grounds. You'd have a tough time defending that on malpractice grounds. I'm not saying it's impossible, but it'd be tough, right? I'm a competent counsel. I'm good counsel. This isn't ineffective assistance of counsel. This is an ineffective assistance of counsel where I'm knowingly and purposely going to forfeit an issue where I have clear binding Court of Appeal precedent, and I'm totally going to forfeit that issue because of these reasons. That's a bit of a hard sell on it. That's a bit of a hard sell if they ever start looking at you the wrong way as the attorney. So, you got to have some balls if you're going to do that. So I don't know what you do in that circumstance. So I don't know if I can fault the attorney on that one, because man, that's a hard one to say. I'm definitely going to knowingly forfeit this issue where I have binding precedent because of this other reason. And it's like, especially because there's no, the binding precedent is your best reversal odds, right? If you really think as the Court of Appeals attorney, if you really think there's binding precedent that tells you the trial court's wrong, this is your best odds of reverse. Of course it is, right? If you're going to the Court of Appeals and be like, I'm going to forfeit this binding precedent, what I'm going to the Court of Appeals with them is the trial court abused its discretion That's totally the basis I'm going to the Court of Appeals on. Yep. I'm going to ignore this binding precedent, and what I'm going to go with is they totally abused their discretion in not allowing that testimony, knowing what the standard of review is for abuse of discretion. What court of appeals attorney is making that decision? You'd have to have balls of steel, man. I mean, we all know how it worked out in the end, but geez, man, it's like, do you have the balls to do that? I don't know. That sounds like a lot. Uncivil, I need to see an eye doctor. I have seen eye doctors, but thank you for your concern. I see many, many doctors. Thank you for your concern. Anyways, I'm going to sign off for now. If you've enjoyed this, please remember to do the like and comment and subscribe. All the YouTube-y things. I appreciate everyone who's here. If you're not a member already, you can join. You might have noticed, for example, when we did the story, we had a list of names on screen, the Uncivilians. And you might say to yourself, wait a second, it's Uncivil, how do I get my name on screen? I want my name on screen. How do I get my name on screen? Well, it's super easy, my friends, to do so. All you have to do, Streamlabs, in fact, just told you how to do it just now. Please the subscribe button. For 99 cents a month, you too can join the army. So click the link or hit the join button as is appropriate. And if you hit the join button or you click the link and pay the 99 cents a month, you will get a cool little icon by your name, the Scales of Justice. That's pretty badass. And also, you'll get your name on screen to show that you're a financial supporter of the channel. That's pretty cool for 99 cents a month. I mean, that's a pretty good deal, just saying. So you get all those wonderful benefits. Hit the join button, hit the link. Join today. Get the icons, become an Uncivilian. You too, by hitting the join button. It's all you need to do. And you get the cool icon and you get your name on screen. As you can see, these lovely Uncivilians have their name on screen right now. So do all those YouTube-y things. I'm going to sign off for now. Until later, my friends, I hope all is well. Cheers and goodbye.